Canny, just tell us what else Israel charged, what else they said at the ICJ this morning.
Well, good afternoon to you, Nzinga, and to the viewers at home. It appears that Israel is stating that our case is one-sided as South Africa to the ICJ, and that there may have been a distortion of the facts or the lens in which they want to view the situation in Gaza. As you've heard from the agent of Israel that presented the opening submission ahead of the legal speeches that will take place afterwards, that Israel is taking a different view, that they, in fact, are defending their sovereignty, and they've accused Hamas of actually putting Palestinians in harm's way.
We saw the King's Council there saying that if there is a genocide, it's the one that's been perpetuated by Hamas in Israel on October 7. So a lot of the argument seemingly centering not on the submissions of the South African team yesterday, moving it away from that and saying, among other things, there's no genocidal intent, quoting from the Prime Minister what he has said in November, saying that they are trying to avoid a loss of civilian lives and they're not fighting against Palestinian civilians, but fighting against Hamas. Take me through that.
Well, I think South Africa was addressing exactly what happened in Gaza. I think their submission centered around the devastation, Palestinians being reduced to just mere dust and rubble, and the clear evidence on the video and image support to substantiate those claims. But however, it's clear in the submissions, or at least the opening submission, as well as what we've heard from the King's Council so far, is that they are addressing South Africa as a state and regarding its conduct towards Hamas and its, I guess, intentions with bringing this application. And as you can see, as the King's Council was rounding up, they've actually even argued before the courts that a dispute wasn't even established under international law. They've diminished those attempts by South Africa to reach out to the State of Israel and said that they hadn't established a dispute before they actually headed to this top UN court.
He said that South Africa also tried to cover up the fact that there is no dispute by then issuing a flurry, what he described as a flurry of notes or note verbals to Israel. Let's come back to the court. We saw Dr. Ty Becker, you took us through that, and Professor Malcolm Shaw, KC, speaking around the jurisdiction and the preservation of rights of parties. After a short break, they said 10 minutes, yesterday it took 20. We're expecting Dr. Garlet Ragun to speak about the facts on the ground. Is what is happening today speaking to the arguments that were presented yesterday, or are there a different set of facts and legal arguments that are being presented today that don't directly speak to what South Africa presented yesterday?
Well, I think this is definitely a response to South Africa's claim. I do feel that yesterday when South Africa was making their submissions, they were spelling out a case, or rather acts of genocide that had taken place. We've seen Israel respond to some of those claims made yesterday regarding the fact that Dr. Becker has stated that it's inconceivable to even term this as a genocide. He's accused South Africa of weaponizing terms, abusing the convention by approaching the court, and rendering them defenseless against Hamas. So in some respect, it is a response to some of the claims that were made, but it does seem that they are addressing, even though South Africa addressed exactly what is happening in Gaza and the situation in Gaza, it does seem that Israel's response centers around South Africa's, I guess, what they claim to be affiliation to Hamas. And they've also reduced some of the acts that were described by lawyers. They've said that Hamas has infiltrated civilian structures in Gaza, and to defend themselves, this is how they've carried out their operation. So they've rejected completely this claim of genocide, and they've stated that if there's anyone who's failing to meet the obligations under the convention, it is South Africa itself, not them. So we're seeing the state completely far remove themselves from the devastation and the atrocities that have taken place in Gaza, and merely reduce their efforts as a means to defend their sovereignty.
Let's go back to those submissions by Shaw, intimating that South Africa shouldn't even be there in the first place. Would it be allowed that you can present your case at the ICJ if you're not meant to be there, perhaps if it's not the right matter for a court to deal with, if you're not the right state to bring that case?
Well, I think you're referring to the argument he raised about how to establish a dispute.
How to establish a dispute, and also the fact that perhaps South Africa had jumped the gun.
Yes, that is the feeling that I got from that submission as well. However, we have seen the various efforts by South Africa. I don't know how it could be interpreted any other way regarding those efforts with respect to fighting for justice for Palestinians in Gaza. We've seen what has happened over the past few months, or the 13 weeks leading up to where we are now. However, for the first time, I've heard this word, unispute, that Shaw spoke of, that they were single-handedly clapping their hands, and that a dispute had not been established. So he was saying that in order for this process to take place, when you reach out to the other states to list those concerns, they need to be given adequate time to respond before you jump to litigation. And that mere non-response from the state didn't establish that there was a dispute between the two states, because remember, to head to the ICJ, you both have to be party members, and a dispute has to be established in which you are asking the ICJ to intervene and provide guidance as the world court. Whether the question of whether these relief or the provisional measures that are sought by South Africa will be successful, and if after that, will it be enforceable? That is a different debate altogether.
I mean, I wish we had a crystal ball to see how important this point might be a little bit later on, Canny. When we come back, we're going to be hearing about the facts on the ground, and then Dr. Omri Sendo is going to speak about the risk of irreparable prejudice and urgency. My English is going there. And the provincial measures requested being unwarranted and prejudicial. Do you feel that up until this point they have laid out a case in law, and I don't talk about the politics, that is strong enough to counter what we have heard yesterday?
That is South Africa,
Israel.
Well, we've only heard from one counsel so far, so I think it would be to the benefit of the viewers for us to hear the full response and to the claims made by South Africa. But we have seen South Africa lay out a compelling case and state for the very least that they should be able, or the court rather, should be able to indicate these provisional measures to avoid further loss in Gaza. So right now we're not dealing with a full determination, and Zinga, we're just dealing with whether South Africa's claim is plausible, and that without those, or the court or the top court indicating those provisional measures, whether there'll be further irreparable harm or prejudice towards the people of Palestine. So this is just the urgent matter that they're dealing with. And then, of course, it would be prudent for us to hear the full response to all of those areas that South Africa has laid out yesterday to the top UN court. And then we'll be able to see from those arguments what exactly the full response from the state will be.
Okay, Canny, let's just, for 1 minute before we wrap up, go to the allegations that have been made and what has been laid out in court, that South Africa is only telling half of the story. There was a quote that was put up saying that, showing that perhaps Advocate Mugaitsi Obi, senior counsel, yesterday had quoted a part of what a minister had said. And Israel's defense, or Israel's counsel, saying that there's a blurring of the story there. Did they lay out quite a lot of evidence around that?
Well, I would have seen it as a speech by the agent of the State of Israel stating that the compelling submissions that we heard yesterday were centered around what occurred in Gaza, but not the action that informed the response. So that is the State of Israel's defense, is that there is a one-sided lens that does not give accountability or responsibility to the organization Hamas, and does not zoom into the October 7 attacks. But we've heard that even if those October 7 attacks, the facts laid out, are truthful, that it doesn't warrant a response of alleged genocide. So we'll continue to hear those arguments and continue to give you those updates as the State of Israel responds in the top UN court to this quite historic and important application that is taking place there at the ICJ.
Canny Maphanga, following the story closely and giving us updates on the legal arguments, they really appreciate your time this afternoon.